Good morning, everyone. Thank you so much for being here on this really exciting morning. Today marks a pivotal moment in the fight for equality and fairness in Minnesota. Cooper v. USA Powerlifting is a historic, unanimous decision, not only to affirm the rights of transgender athletes to fully participate in sports, but also affirms their dignity and place in our society. Gender justice envisions a world where everyone can thrive no matter their gender, gender expression, or sexual orientation. And with our co-counsel Nicholas Castor, Schlesinger PLLC, and Primo Frank, we took this case back in 2019 because we knew even then that there was a growing, unprecedented legal, legislative, and messaging campaign orchestrated by anti-LGBTQ hate groups to deny transgender people basic human rights and push them out of society altogether. This case has always been about something fundamental to who we are as Minnesotans, that we believe in the right to live free from discrimination, pursue our dreams, whether that's excelling in athletics, advancing in our career, or simply living openly as our authentic selves. And frankly, it's an integral part of being an American to participate in sports. Last year, nearly 80% of all Americans aged 6 or older participated in at least one sport activity. People of all ages in every corner of this country participate in sport to learn teamwork, be healthy, be part of a team, and have a sense of belonging in their community. Minnesota has long been a leader in advancing justice, and we are proud to be a trans refuge state, providing hope, support, and safety amid a national landscape that has grown increasingly hostile to transgender people. We're so glad to gather today and celebrate this win for dignity and humanity and fairness. And for the legal details of today's win, I will turn it over to Gender Justice Legal Director Jess Braverman.
Hi, everyone. As Erin said, this is a huge win, and we are so proud. So the ruling might be a bit confusing to folks who are looking at it in terms of like, what did the court do? What did it say? And so the court was looking at two different claims. One was discrimination in public accommodations. The other was discrimination in business. As to discrimination in public accommodations, the court found USA Powerlifting liable for discrimination. In other words, that when it comes to discrimination in public accommodation, you cannot bar transgender women from women's sports teams. And that is a huge victory. We are so proud. The rest of the ruling is about remaining claims that at this point we don't really need to go into because we won on public accommodations. But there are other claims that if there's questions about what those mean, feel free to ask. But those are separate business claims. But this is just it's a massive win, and we're really excited. The other thing the court did was it looked at this older case, Goins v. West Group, which was about bathroom access and employment. The court basically said it wasn't going to rule one way or another on whether Goins was properly decided. What it said was we're waiting for for an employment case to come along, and once that employment case comes along, we'll revisit Goins. And so we today we read this opinion. Obviously, it's only been 1 short hour since it's come down, but we're really thrilled. And I would welcome any questions, but for now, I'll send it back to Erin.
Thanks, Jess. Real quick, I want to invite Chris Mosier, who is a trans athlete and advocate, to just talk a little bit about what this ruling means for trans athletes, the impact of what we've seen in Minnesota and nationally, and why sport is so important. Take it away, Chris.
Thank you, Erin. Hi, everyone. My name is Chris Mosier. My pronouns are he and him, and I'm a trans athlete and activist working for gender liberation in sports and beyond. And I am so thrilled to be here with you all to celebrate this incredible ruling, because for so many of us, sport is our safe space. So many members of the trans and non-binary community, and that might be somewhat unbelievable to folks to hear given the state of politics around the inclusion of trans athletes in sports. But it truly is a space where we can be with others and work towards a common goal and feel a sense of belonging and purpose and community, which is so incredibly important to us now more than ever. And that's really what sport is about at the end of the day. It's about being in community with other people who share an interest, because sport has the ability to unite us like very few things in the world really can. It's a space where we can make lifelong friends. And so we know that this ruling is significant for the trans community and our allies, and it affirms what we know to be true, which is, first of all, Minnesota is a leader in transgender rights. And also, trans people belong in sports and in every other space in our world. Trans people deserve the opportunities to participate with our peers in every facet of public life. And in my work, I've had the opportunity to mentor and work with trans and non-binary athletes from the youth level all the way up to professional athletes. We know that there has been a strategic, coordinated attempt to paint transgender people as a danger in sports so that they can say that we are a threat everywhere else. So this ruling is a profound one for this moment in time because there is a truly negative impact when transgender people are excluded, not just for the trans community and non-binary people, but for everyone on the team. Because this type of discrimination, excluding people because they are transgender, creates a more dangerous space for all athletes, not just the transgender ones. But I have seen the ways that affirming and supportive teams can thrive when every athlete is welcomed and given the conditions to show up authentically. It's not just the transgender people who benefit. In these spaces, we have those opportunities to meet people that we otherwise might never meet or talk to. And teamwork is really about caring for others, and nothing helps us learn that more clearly than participating in sports. As Aaron said, sport is part of American culture, and so we must continue to ensure that every American, from our young people in sports who just want to learn dedication and communication and leadership through fun activities like school sports, to our adult recreational athletes who find that sense of community and belonging that's so important in our world today. We must continue to stand up for the trans community. So this is a significant day for us. We are thrilled with this decision. And I'm also just very excited to see Minnesota leading the way by unanimously affirming that trans people belong.
Thank you so much, Chris. I am going to turn it over for questions, but I do want to point folks to an open letter that was released ahead of the decision today with over 2,000 athletes, coaches, parents, and advocates, supporting trans inclusion in sports. And we can share the link in the chat here, but this really is about coming together and showing the best of ourselves. And that's what this decision is today. And with that, I will turn it over for questions. You can raise your hand. I'll call on you. And then if you have questions you need to put in the chat, feel free. I'll come to you first, Caroline.
Hi there.
If you could say your name, sorry, and your outlet. Thank you.
Caroline Cummings, WCCO TV. Just a question on the kind of two issues here. It's I know you're saying that the public accommodation one is essential, right? That's saying that JC Cooper had the right to compete and they discriminated against her. But what does that that second part mean in practice? It's talking about, like, and I'm no lawyer, that there's a dispute over the facts on the business accommodation, because I guess that's an exemption under the law. So does that mean that that issue goes back to the district court to rule on? And if so, like, could a different ruling from a district court on that matter, if USA Powerlifting was to prove that they had a legitimate business exemption, could that unravel the protections on the public accommodation or impede her ability to compete? Sorry, that was really convoluted.
No. So the end of the opinion may have been a bit confusing, but basically it said we won on public accommodations. There is this separate piece in any business claim that involves you can discriminate in a sense if you have a legitimate business interest, but even if USA Powerlifting proved that they had one here, it would not unravel the win because public accommodations does not have that exemption. So JC Cooper won on public accommodations. That's not changing no matter what. On the business claim, the court really limited what USAPL could even say to justify what they did. It has to not be based on generalizations. It has to not be based on stereotypes. You can't discriminate against all trans women just because you think some may be stronger than cisgender women. So what they could do with the opening the court gave them is really limited, but it would only apply to the business claim, not to the public accommodations claim. The public accommodations claim will not be unraveled. She won on summary judgment on that claim, which means that she won on that claim, period.
If I may, just a quick follow-up.
Okay.
I understand now, what you're saying about that
Yep.
wouldn't, there's two separate issues, but if they were to be successful on the business claim, since they are a business, would that have any bearing on the issue of trans women being able to compete? Or are we talking about two different things when we talk about like being able to play? Because I just see the business, right, as like, if this is a business operating to exist, makes money off of people competing, like wouldn't that at all have any correlation? Or maybe it doesn't, and that's just what I'm trying to understand.
No, I mean what we're saying here is USA Powerlifting is two things. They're a business and a place of public accommodation. The court agreed with us there, but I don't know of any sports organization that is a business but not a public accommodation. So it would be a very narrow situation that I can't even imagine sitting here right now of what would qualify as a business but not a public accommodation. We just brought this case under two alternate theories. We don't need both, and we won on public accommodations. If someone did fall in this really, really, really narrow land where the only thing they are under the Human Rights Act is a business, and again, I don't even know what that would be, then no, it doesn't mean they could discriminate. It would mean that they would have to basically find the least restrictive policy, assuming they even had a legitimate reason for doing what they're doing to begin with. So the only way something could live in this really narrow carve out is if it's not a public accommodation, it's not an employer, it's not an education facility. It's like just a business, does not fall in any of those other categories, and has a really narrow policy to achieve its goals. And so there's not a lot of room in there for people to discriminate. Does that answer your question a bit?
Yes, it does. Thank you for that.
Okay.
That they kind of go hand in hand, essentially.
We call it in law, like it's an alternative theory. Like they're a public accommodation. In the alternative, they're also a business. And we do this all the time in cases, so that can lead to confusion, but we only need to win on one, which we did. And the other one is, we'll see what happens with that if we pursue it at this point.
Thank you. I'm going to go to the person named KSTP Cooper. If you could just say your name and the outlet you're with.
Yeah, Renee Cooper, KSTP. So I guess I'm going off what Caroline said here. It is just tough to understand in terms of, because if it goes back, or it is going back to the district court, and if I'm understanding correctly, you're saying you're very confident that this legal argument, this possible legal argument that the Supreme Court lays out for USA Powerlifting, you're not worried about that, one, that you think it's too narrow and doesn't fit here, and two, what if if the district court does decide that exemption fits here, and now you have two sort of competing rulings, what does that effectively mean for her ability to compete?
They would not be competing rulings. USA Powerlifting is a public accommodation, and they cannot discriminate. So it wouldn't be a competing ruling. Ms. Cooper won. USA Powerlifting lost on liability. We're going back to deal with issues such as damages and that sort of thing. Even if we took the business claim to its end, and even if USA Powerlifting were successful on that, they would still lose on public accommodations and be liable to her for discrimination. So no matter what, this court found that USA Powerlifting discriminated and violated Minnesota law. There's just two claims that these are two separate claims. And so even if they win on the second, it does not change the fact that they discriminated and it was illegal.
Renee, do you have a follow-up? Yep, go ahead.
Does she plan to continue competing with USA Powerlifting?
We'll have to discuss that with her. This case has been going on for such a long time, so we'll have ongoing conversations about that. But just remember this arose out of incidents that occurred in 2018.
Thank you.
Caroline, if you don't have any more questions, because I see your hand is still up, I'm going to go to Margaret Heatherman. If you could just introduce yourself and say the outlet you're with.
Hi, sorry, I was trying to unmute. Yes, Margaret writing for Go Magazine. Obviously a huge day. Um, two questions from the layperson perspective with regard to the law. Can you just firm up for me, first of all, whether this is going to apply to all sports in Minnesota? And apologies if I missed that. And secondly, what impacts could, if any, this have on future SCOTUS decisions in terms of, federal implications?
Yeah, those are great questions. So this ruling, it definitely applies in public in sports organizations that are considered public accommodations. So those are, membership-based organizations, let's say organizations that hold events in Minnesota that have members in Minnesota. The logic of the ruling, this wasn't an education case. This wasn't discrimination that took place in an education context. But the logic of the ruling, I would say, would apply in the education context. There's no it's very similarly written to the public accommodations. It does not have the carve out that we talked about from the business claim. So I would say that the logic of this ruling would make it to me, it's pretty clear that this would apply in the context of school sports. Um, and so it is a very broad ruling. In terms of the federal implications, that's a great question. So we know the U.S. Supreme Court is going to deal with the question of whether Title IX protects transgender athletes. Um, I think there's a sort of question along with that some people would like the court to find that Title IX requires schools to discriminate against trans athletes. We'll have to really see how that ruling shakes out to determine um, where we go from here, basically. However, Minnesota's public accommodation law is what it is, and the Supreme Court's not undoing that no matter what happens on those school cases. And so I'm not aware of any case right now that's going through the courts that's making its way over to the Supreme Court that would undo the win we had here today. I think the only open question is whether the Supreme Court issues a ruling that has implications in the school context. We'll have to wait and see what they do.
Thanks, Jess. And Margaret, do you have a
Thank
follow-up?
you. Thank you. So it sounds like Minnesota won't be impacted in any negative way or dependent on SCOTUS for future decisions. But it may or may not impact the other states in terms of SCOTUS decisions.
A ruling in the SCOTUS case that says that Title IX requires schools to discriminate against trans kids could potentially have an impact here in Minnesota. A ruling by the U.S. Supreme Court that says Title IX just doesn't say one way or another, schools decide, states decide, would be a different story. So there's a lot of different possible outcomes with SCOTUS and how SCOTUS could impact us here in Minnesota. But yes, the ruling here today applies to Minnesota's human rights law. I think other state courts around the country who have similar protections to ours will look at this for guidance. They don't have to follow it because they're not in Minnesota, but there are other states in this country that have laws similar to what we have, and our hope is certainly that they look at this case and say, you know what, this is true for our law too, and we're going to follow that. So it is up to them, but we think this is a really good example of how courts should proceed if the issue's in front of them in a state that has a law similar to ours.
Thank you. And lastly, just in terms of that, and looking at the press release, the mention of gender dysphoria with the application, that is not, that doesn't have anything to do with the quote public accommodation, right? We're talking about accommodating people just simply for humanitarian reasons, not because of a quote diagnosis.
She did not the win had absolutely nothing to do with whether or not she had a gender dysphoria diagnosis. That issue only came up because there's special rulings around what medications athletes can take.
Okay.
There's some medications that are used for multiple things, right? Like spironolactone is used by cisgender women, by transgender women. It's used for a whole host of things. It does not provide a performance enhancement, but it some people believe it could be used to hide doping. And so it's banned for that reason. However, typically when people say I'm using spironolactone, they're allowed to compete. You just have to put in what's called a therapeutic use exemption. So this case started when Ms. Cooper put in a therapeutic use exemption for spironolactone. Those are approved all the time. They're approved for cisgender athletes as well, who also take this medication. That's the only reason the gender dysphoria diagnosis was even an issue here, because that medication is related to that diagnosis, but none of that has anything to do with the court's ruling today. She won because they discriminated against transgender people. You do not need a diagnosis to fall under today's ruling.
Thank you so much.
Thank you. Next, we're going to go to Michelle Griffith. If you could just introduce yourself, say your outlet, and you can ask your question.
Hi, Michelle Griffith, Minnesota Reformer. Could you clarify? So the court, sent, it sent the case back to the lower court to determine if USA Powerlifting has a legitimate business purpose for excluding her. If a lower court does conclude that, does that at all impact the public accommodations part of the case, or so that's just totally separate? Sorry if you've already
It's
asked.
totally separate. It does not impact the public accommodations case.
Okay.
So
And
what
what are like the impacts of concluding about a legitimate business purpose?
if that issue even gets litigated, it's just what we call an alternative theory. Like sometimes we bring a case under more than one theory, and that's what we did here. So it doesn't really impact the outcome. We said they're a public accommodation and also they're a business. Those are two separate provisions of law. And so it's what we call like an alternate theory. So you could be both, you could be one or the other. Here, the court clearly found that they are a public accommodation and that they are liable for discrimination on that theory. So this is just kind of a second theory we could pursue, but don't, we'll discuss that with our client, whether we plan on doing that at this time.
Okay, thanks.
Thanks, Michelle. Allison, come off mute and introduce yourself, your outlet, and then you can ask your question.
Thanks so much for being here. I'm Allison Kighton with the Star Tribune. I wonder if you can speak kind of to the level of protection this ruling provides. Obviously, this is a statutory ruling, and there's been efforts by Republicans in the legislature to amend the Minnesota Human Rights Act. Is there potential for maybe a constitutional case along these lines in the future, or can you just kind of speak to the level of protection here?
Yeah, so the constitutional claims only, they typically apply to the government. So they would apply to, let's say, public schools is a really common type of case we bring. That would include constitutional claims. The only constitutional ruling I'm aware of in the state of Minnesota on protections for transgender people is a case we brought a few years back, the NHV Anoka Hennepin School District, where the Minnesota Court of Appeals found in favor of our client who is a transgender student on an equal protection theory under the Minnesota Constitution. So right now, our Constitution protects transgender people from discrimination by government actors such as schools. USA Powerlifting, I can't imagine what type of constitutional claim they would have access to in a case like this. They'd have to argue that somehow this law violates their constitutional rights in Minnesota, and I'm not really sure what claim they would have there. So I would leave that to an issue between them and their attorney, but it's not something I foresee or I'm concerned about. And right now, the ruling from the Court of Appeals, which is not the Minnesota Supreme Court, but it is what we call precedential, meaning it applies all across the state, is that the Minnesota Constitution protects transgender people from discrimination.
And Jess, it might be helpful to clarify too that this case, because it was brought from actions that happened in 2018 and filed in 2021, is under the Minnesota Human Rights Act as it existed at that time and not the one we have right now.
There is nothing about this ruling that doesn't apply to the Minnesota Human Rights Act as it is now. But yes, that's why the sexual orientation language is in there, because there was different language in the language changed, the rights did not.
Yeah. Renee Cooper, coming back to you.
Yeah, I just wanted to go back to when it was said a few minutes ago about how this ruling would apply to school sports. Could you expand on that? Like, how does this apply to school sports?
Yeah, so the Minnesota Human Rights Act is a really broad anti-discrimination law. It includes different provisions. So public accommodations, separate from that is business, separate from that is education, employment, so on. The issue here that we raised to the court and the court agreed with us is if you have a policy that bans transgender girls from girls' sports, does that policy violate the law? Our court said yes, unless there's some exception in the Minnesota Human Rights Act that allows you to do this. There is no exception in the public accommodations provision. And so that's the provision the court looked at. But there also is no exception in the education provision. So I don't think there's any rational argument for reading those two claims differently. Like if this had been a school case, or if we bring a future school case, I would expect it to come out the exact same way because the statute governing school issues is very similar to the statute governing public accommodations. The exception we talked about earlier is unique to business claims, but that exception is not present in the education context. So I would expect an education case to come out the same way.
So it doesn't expressly speak to education or expressly apply to it, but you expect that it sets precedent for school sports.
Yes, I think a school that wanted to discriminate would have a very difficult time explaining why the Cooper ruling does not apply to schools. I don't even know, given the court's ruling, I'm not even sure how they would go about making that argument. I guess we'd have to see what happens if we do have to litigate that case, but I think they would have a very, very tough road ahead of them if they wanted to try to make that argument.
Thank you.
Thanks, Renee. Caroline, coming back to you.
Yes, Caroline Cummings with WCCO again here. I know we're talking obviously about state court, so this would not be any sort of binding precedent on anything other than Minnesota, but I'm wondering if at all you anticipate or could see how this would interplay with some of the lawsuits of the Trump administration on Title IX issues related to high school sports. I mean, obviously this ruling wouldn't supersede any federal court on that front, but like, does it bolster the state's case when they try to argue against those Title IX lawsuits, or are these really or are we looking at really two issues that are related but are separate and don't really interplay with each other?
I think, all along our state has said that the Trump administration is trying to force us to violate our own laws. The federal government right now is trying to force us to violate the Minnesota Human Rights Act. The ruling today affirms that our state is right about that. Like when the federal government comes in and says you must discriminate against transgender people, our government is right when we come back and say, well, our law requires us to be inclusive. It requires us not to discriminate, and you're forcing us to break our own law. And so I think it affirms what the state has been saying about the state of our state law. There is kind of complicated stuff that happens when you have a federal legal claim, a federal law and a state law, and those laws actually conflict. And the thing we have to see is, do those laws actually conflict? Right now, most courts who've ruled on Title IX have said that Title IX protects trans students from discrimination. That's consistent with Minnesota law. So right now, I don't believe there's a conflict. If the Supreme Court said Title IX just doesn't really say one way or the other, Title IX allows schools to have, men's teams and women's teams, but it doesn't say on what team a transgender athlete must be put, then there's no conflict, right? Our law says you have to allow trans women, for example, to compete in women's sports, and so there'd be no conflict. And so the only issue will come up if the Supreme Court rules on Title IX in a way where it actually conflicts with our state law, and we don't know yet whether or not that would happen.
Any follow-up, Caroline?
Nope, I'm good. Thank you.
Okay, thanks. John Parker, I'm going to come over to you. Introduce yourself and your outlet. You may ask your question.
Yeah, hi, John Parker, AM 950 Radio, KTNF. I'm curious, and this is just my ignorance about what's covered under public accommodation. If a church has a softball league, is there a religious exemption on this, or does this law cover any like church or synagogue or mosque that has a softball or any type of sports team?
And so is the question, would there be like a religious exemption?
Yeah.
I guess we'd have to see if you know, I think that's a good question. I think it raises a lot of interesting issues. I think that if, let's say, a church had their own church softball team and someone's told that church the Minnesota Human Rights Act requires you to be inclusive, that church might bring a religious liberties claim under the state constitution in that event. And we'd have to see how that would play out in the courts. Right now, I'm comfortable that's a pretty narrow. What you're naming is pretty narrow, so I'm not sure how much that would arise. But this case doesn't really address the issue of what if someone says this violates my this burdens my religious practice or something to that effect. I think then we'd have to see how the court deals with a case like that.
Thanks. I'll go to you, Ellie Roth, if you want to introduce yourself and say the outlet you're with.
Hi, Ellie Roth with Minnesota Public Radio here. I'm curious, Senator May-Quade, if you have any concerns, or do you think it's possible that the legislature would be able to reverse something like this?
Is that a question for me?
Counteract
it was
the Supreme Court's decisions.
Ellie, sorry you cut out there, but I'm
sorry.
It's okay. I did catch the beginning of your question. I'm serving as in my role as the senior advisor to gender justice, the nonprofit I work at.
Yeah, this could be for anyone here, but I'm curious if there are concerns or if you guys are worried at all that the legislature could reverse this in any way or write into state law something that makes this decision moot. Hopefully that came through.
Oh, they cannot undo the win. Ms. Cooper won under the law as it stood at the time that this happened to her, and so they can't undo the fact that she won. The legislature could try to change our Human Rights Act, and we may have arguments that changes to that are unconstitutional. We'd have to wait and see what it was they tried to do and go from there.
Ellie, any other questions?
Nope, that's all. Thank you.
Great. Jeff Day, if you want to come off mute, introduce yourself and name your outlet, you can ask your question.
Thank you very much. This is Jeff Day with the Star Tribune. I was curious if Ms. Cooper has had any response to this or how this process has kind of played out for her. I remember at the oral arguments, that she was not wanting to be front and center of the issue, but I just kind of wonder how this opinion has affected her, or if you've had time to talk to her yet. I guess I'm not sure about that. But even if just speaking through the process of representing her throughout this case, what this has been like for her.
I cannot overstate how difficult it is to be a plaintiff in a civil rights case. It's maybe one of the most difficult thing a person can voluntarily take on. And when I say voluntarily, I use that term loosely because by the time someone comes to us, they're being discriminated against. And so I think there's a lot of emotions going on right now, and she'll definitely, as do I, need some time to process this win. But I can say that I know this ruling means a lot to, I've heard from parents of transgender kids of how much this means to them. One told me yesterday, like, thank you for helping our child have a normal childhood, because at this point, trans kids are under such vicious attacks all around the country. I know that it means so much to folks to be able to look at their kid and say, like, you can be a kid, like you can play sports, you can do all the, you could go to the mall with your friends, and you could do all the public accommodations things that everyone else can take for granted. So I know this ruling is just massively meaningful for a lot of people in Minnesota.
Thank you very much.
Thanks. All right, I'll just hold for about 10 more seconds here to see if there are any additional questions. Obviously, legal cases are complex, and we appreciate all the questions to make sure that we're getting it right. But just a truly fantastic day here in Minnesota, a great win for our client JC, but like Jess said, for so many other people in Minnesota to just live lives of dignity and have a place in our society. I really quickly, just before we close, again, want to thank our co-counsel, Nicholas Castor, Schlesinger PLLC, and Primo Frank. We do have one of our co-counsel here, Riley. If you wanted to say anything, please feel free to, but you don't feel pressured to do so. We're so grateful that we have co-counsel in these cases because we are a small but mighty nonprofit, and our co-counsel is really how we get this done.
Thank you, Aaron. It's an extreme privilege to be able to work with gender justice on this case. And I think the only thing I would add to the comments here today are that not only did the court hold for Ms. Cooper, but the court also reaffirmed multiple bedrock principles of the MHRA, which really serves as an important reminder that the attacks on transgender rights are not just attacks on trans people. The issues raised in these cases implicate the rights of all Minnesotans. So I'm really glad that the Minnesota Supreme Court held today on the side of civil rights for everyone, not just a select group.
Thank you, Riley, and unanimously, which is just wonderful. Caroline, I see your hand raised.
Sorry, I thought I was done, but I know you touched a little bit on the, is it Goins case that Ms. Cooper had wanted the Supreme Court to rule on. I know, I think it was you just said that that the court made clear that that was, the scope was employment and we weren't talking about employment here, but are you at all disappointed that the court didn't weigh in on that issue? Because I know, and I'm paraphrasing here, I know that some of the arguments made was that was kind of an outlier or an anomaly in Minnesota's laws protecting trans people, that ruling from 2 decades ago said that employer did not discriminate against a trans person on a bathroom issue. Again, I might be oversimplifying, but is that a disappointment? And why did you seek that in this maybe?
That's a great question. So the court, I would say the court cabined Goins to employment, and I'm happy about that. So Goins won't wreak havoc in other areas of public life that people participate in. I'm disappointed, yes, because I think it's a blight on our state. I think it's a really terrible ruling. It's terribly reasoned, and I cannot wait to see it overturned. But I am confident that if we brought an employment case with the right facts in front of the court, that we would be successful. So the court did not say Goins was correctly decided. It just said this isn't an employment case. And so the only time we'll revisit Goins is if it's an employment case. But in the meantime, Goins doesn't apply outside the employment case. And so I think the court did a lot of work limiting Goins. And we look forward to, I hope no one's being discriminated against in the way that Goins was, but if that happens, we look forward to getting Goins overturned in a future case.
Thank you, Jess. All right, last call for questions. You also have our press release. If you have questions, feel free to reach out to Gender Justice. We'd be happy to answer any questions about the details to make sure that it is right. We are so grateful to you for joining us today to talk about this historic, unanimous landmark win for Minnesotans, for all Minnesotans, as Riley pointed out, and really affirming the bedrock principles of the Minnesota Human Rights Act. And with that, we'll close. Thank you so much.